Hello, everyone, and welcome to day 2 of our series of webinars entitled Bicontinental Perspectives on Legislative Drafting. My name is Kimberly Faith, and I'm this year's chair of the International Conference on Legislation and Law Reform. For those of you that weren't able to join us yesterday, this conference focuses on how laws are written in the United States and around the world at the national, international, and subnational levels. However, the 2021 conference has been postponed due to COVID-19. So this series of webinars features several renowned experts on legislative drafting who were invited to speak at the conference but were unable to do so. I want to again give a huge thank you to the University of Pennsylvania Carey School of Law for partnering with us in order to bring you these webinars. I'd also like to thank the conference organizers who volunteer their time to plan events like this for our international community of legislative professionals. Introducing our speaker today and moderating the session will be Professor Lou Rulli. Prior to joining the Penn Law faculty, he spent over 20 years working to expand access to justice to the poor through the community legal services in Philadelphia, including almost a decade as the executive director. Lou is now the director of the Civil Practice Clinic and Legislative Clinic at the University of Pennsylvania Carey School of Law, where he has won multiple awards for his teaching. Thank you, everyone, again for coming to the presentation today. And Lou, I will pass it over to you.
Thank you, Kim, for that very generous introduction. On behalf of the planners, it's my great pleasure to welcome everyone to the second webinar on Bicontinental Perspectives on Legislative Drafting. We had a great session yesterday, and today promises to be equally exciting and informative. I have the great pleasure today to serve as moderator in this webinar, and it is my sincere privilege to present to you Dr. Matthias Rossi, a renowned expert on legislation. But before doing so, I have one housekeeping item that I have to share with you. Professor Rossi will speak for about 30 minutes, after which we will have a Q&A for about 20 minutes. I urge you to submit questions as you're listening to Dr. Rossi. To do so, please just simply use the Q&A feature on the bottom of your screen to submit your questions. Please keep your questions topical and appropriate, and I will try my best to pose as many questions as possible to Dr. Rossi following his presentation. And now it is my great pleasure to introduce Dr. Rossi. Professor Rossi holds the chair for Constitutional Law, Administrative Law, EU Law, and Legislation Theory on the law faculty of Augsburg University in Germany. He served as the Dean of the Faculty of Law from 2017 until 2019, and he is a recognized legislation expert in Europe and around the globe. He studied law in Germany and France, and he earned a doctorate from the Humboldt University in Berlin. He served as a visiting professor in India, France, and Italy. We are extremely fortunate to have Professor Rossi with us today to share his ideas on the subject of legislation as an interdisciplinary challenge. It's a critical question for all of us as we look at how democratic legislators secure the expert knowledge they need to inform their legislative and political decision-making. Without further ado, I turn the virtual podium over to Professor Rossi, who joins you from Germany in his office. Thank you, Dr. Rossi.
Thank you, Lou, for the very kind introduction, and good morning, good afternoon, and good evening to all of you, depending on where you are listening to me from. I'm very pleased to have the opportunity to contribute to this webinar today. Also, of course, I would much rather have been live in Washington. In any case, I sincerely thank everyone involved, the team of iLegis as well as the team at Pennsylvania Carey School of Law. Thank you so much for having me with you today. The very first thing I have to say is a word about my topic. And when I now share my screen to make you see my presentation, you will remark that I have changed the subtitle a little bit. To be honest, I had to explain twice to the organizers what my talk will be about. Perhaps the term interdisciplinarity is not very well chosen in this respect because it sounds very scientific, and it sounds above all as if I'm talking about an exchange within the scientific community. Scientists, after all, sometimes have a habit of speaking in technical terms in foreign words. And this is certainly much more true for Germany than for the United States. I always envy the US legal community for its clear and understandable language. But in any case, I can reassure you, I have understood correctly, most of you come from the practice. You are concerned with real legislation in quite different ways and not so much with their observation. And so if I focus my topic a little bit more on practice than under the concept of interdisciplinarity, it should be about how legislators get the information they need to make good laws, how they evaluate that information, and how they bring together the individual pieces of information from different fields. So you see, I'm interested in legal practice, thereby not so much regarding the application and interpretation of law, but instead the question of what role the interdisciplinarity plays in terms of the creation of law, or at least what role it is supposed to play and how it is implemented. That is because the political decision-making invariably relies on skilled expertise, and the interaction of democratically legitimized lawmaking and factually justified knowledge frequently indicates that legislation is an interdisciplinary challenge. So, using German law and European law as examples, I want to show you what tools are available to provide legislators with the expertise they need. Of course, I'm aware that both legislative processes, German and European, are very special and differ above all from US legislation or the country you may come from. But that's the attraction of this webinar, that we all get to know different procedures. My final thoughts, by the way, will then be on a more abstract level, bringing us all together again, regardless of the design of the particular legislative process. It will ultimately be about the question of the relationship between expertise and democracy. Or in other words, how expert information and political decision-making relate to each other. I won't have an answer to that, however, but hope that we can talk about it together first in the discussion that follows on my contribution and later in the individual rooms. One last note, please apologize, I've got a cold and therefore do not have such a strong voice. I hope everybody can hear me clearly. So let's go right into the topic now. That interdisciplinarity is essential for the creation of law. I think it's beyond debate. Assuming that law wants to shape an actual and social reality, the comprehension of reality as well as its shaping requires interdisciplinary instruments. The shaping and controlling powers of law require, first of all, the comprehension of the reality that it intends to influence. Addressing, let alone overcoming, climate change, for instance, is not possible without taking into account scientific connections. Or containing and controlling crime is not promising without analyzing its root causes. And the regulation of the housing market that is subject to civil law requires information regarding supply and demand, to name only 3 examples, and without making reference to the corona crisis as being emblematic for action under uncertainty. Without a reliable data source, good lawmaking is not achievable. Therefore, knowledge about society, about the economy, about the environment is needed. And it requires knowledge about the enforceability of laws. And likewise, one must become aware of the repercussions that laws have, or at least can have, on the political system. However, shaping the reality does also demand interdisciplinarity. This holds true for the legal linguistic, the statutory system, but above all for the probable effect of the law. Predictions regarding the causal process, considerations regarding the likely societal legitimacies, and the anticipation of unwanted side effects require imparting knowledge that overwhelm both the expertise of certain ministerial departments as well as arguably the entire organizational unit. Because the understanding of society, economy, environment, and so on requires the social sciences, the economic sciences, the natural sciences, as well as administrative sciences, political sciences, and linguistics. The knowledge that the state needs for legal judgments is only partly available. As long as the state does not dispose of respective information, certain experts or whole expert committees will be involved in the official decision-making process. When viewing a typical legislative procedure in Germany, it becomes apparent that the ways in which interdisciplinarity is included in the legislation are manifold. They could be categorized by actors, by the degree of their independence, by the reputation of their expertise, or the binding effect of their decisions. Equally, institutionalized and informal instruments could be differentiated. I would like to address some of these, all of which are examples and by no means exhaustive. Providing a comprehensive overview is not possible at this point. Therefore, I will solely focus on the phase of the creation of law that is, though not constitutionally laid down, governed in Germany by the rules of procedure of the federal government. I'm well aware that in doing so, I will disregard all stages prior to the phase of the creation of law, such as the deliberation as well as written consideration of civil society, be it by trade associations, NGOs dedicated to certain aspects of the common good, or by political parties. Other states or the Länder of Germany also provide important impetus. Therefore, I would like to call to mind that these informal and unofficial undertakings are not to be underestimated. They are more than just gateways for politically motivated lobbyism. Rather, they do not only express wishes from people affected, but also incorporate knowledge into the legislative procedure that is not easily available to the state. The involvement of those affected is therefore an important gateway for interdisciplinarity in the legislation. Without going into too much detail, I will describe very roughly a typical legislative process in Germany now. So the vast majority of laws are drafted by the government. And within the government, a certain unit in the ministry is initially charged with drafting a bill. So these are very few people, as you may know, for it may be you who is responsible for writing a bill. Of course, they coordinate with other units in advance, and at some point, the other ministries in particular have to be involved. And in the end, the entire government has to vote on a bill before it moves on to the parliamentary procedure. For once today, I will dispense with the necessary involvement of the Bundesrat, the Chamber of the Länder, and concentrate solely on the procedure in the parliament. It is characterized by extensive preparatory work in the individual committees before the plenum as a whole has to decide at the end of what is usually a third reading. So when we now look at the internal governmental drafting phase that precedes the tabling of a bill, interdisciplinarity is not only achieved by involving the civil society, i.e. associations, affected groups and persons, the professional public and so on, but also through the involvement of other ministries, public offices and special authorities. Concerning environmental issues, for example, the Umweltbundesamt, our federal environmental agency, in its competencies not to compare with the US EPA, is involved. Naturally, this coordination is primarily harnessed for the opportunity of political influences, all the more so when there's a coalition government, which is the rule in Germany. Ideally, however, the ministries and potentially their sub-authorities' expertise shall be utilized. This, for instance, applies to the relationship between the economic and the environmental ministry to address the classic dispute between economy and ecology. The communication between them does not only regard the political wishes, but knowledge concerning the reality that is to be shaped. Similar characteristics apply to the involvement of committees in the parliamentary consulting phase. Therein, various committees are involved and expert hearings are conducted. For one, their significance is not to be overestimated. That is because the experts are proposed by political factions and therefore commonly takes a somewhat biased position towards their political aims. Conversely, their significance is not to be underestimated, and that is because the hearings are public and are perceived by the public accordingly, which lends some substance to them. Finally, with regard to the involvement of the Federal Council, the Bundesrat itself does usually not organize its own hearing of experts anymore. However, this shall not hide the fact that the involvement of the Bundesrat into the legislative procedure is yet another gateway for interdisciplinarity, since the members of the Bundesrat are advised by their own ministries. So let me leave the perspective of the legislative expertise and emphasis another systematization. The involvement of external expertise into the political decision-making process can also be differentiated by where the expertise has been built and how it enters the legislative process. Thus, a distinction can be made according to whether the expertise comes more from the government sector or more from the civil society. And the reason for this perspective is, I think the same for all states at the moment, is the corona measures that admittedly have been passed by the federal states, but that have been largely based on the recommendations of the Robert Koch Institute, the Standing Vaccine Commission, as well as the so-called Leopoldina, which is our National Academy of Science. They competed with associations and private individuals for the interpretational sovereignty of the current threat environment, and partly with the government for recommendation of future politics. So regardless of the question of what role these actors ought to play in sovereign decisions, they clearly demonstrate that a state is well advised when it holds institutions that generate knowledge, which is valuable if needed. This too is a form of tackling interdisciplinary challenge of legislation. But this is not to say, it's not what I wanted to say, that government-generated knowledge is automatically better than privately generated knowledge. Instead, I think only plurality ensures correct knowledge. The way in which external knowledge is held for lawmaking purposes and called upon when needed leads me to take a closer look now at the European legislation. Given that the bulk of national legislation in Germany primarily serves the implementation of European directives, the question of how expertise is incorporated in European lawmaking is of utmost importance. So let's look very roughly at the European legislative process. The procedure is characterized by a large monopoly of initiative on the part of the European Commission. Subsequently, up to 2 readings are scheduled in the Parliament and the Council. If no agreement is reached, the so-called conciliation committee is convened, whose proposal is then adopted or not in a 3rd reading. In political practice, however, decisions are largely made in a so-called unofficial trialogue, so that the further procedural steps are not necessary anymore. That this practice violates, the way I see it, the treaties. I will only mention in passing because my opinion will not change the practice. But let me really assume the way I see it, this informal trialogue is unlawful. But it is more important to me now to emphasize that because the process is abbreviated, the design phase is all the more important for incorporating expertise. And because of its monopoly-like right of initiative and its derived legislative powers, the focus will be on the Commission. And the Commission, due to a lack of personal resources and political involvement in practice, shapes its power to legislation by a high demand for information and the need to network with the regulatory environment. So the Commission has met the structural challenge chiefly by establishing a system of approximately 1,000 or even more so-called expert groups. These groups are not integrated into the institutional structure of the European Union. That said, they have become an integral and functionally necessary part of the Commission's structures, hence why it's hard to envision European legislation without them. In regard to procedural law, expert groups are involved in the stage of legislative preparation, specifically in the phases of legislative planning and drafting. And these are part of the so-called internal and hardly regulated Commission procedure that precedes the actual decision. The formal decision-making powers remains with the Commission itself. The Commission's understanding of expertise is very broad and includes not only scientific, but also practical and interest-based knowledge. And therefore, symbolically at least, the Commission pursues a so-called democratization of expertise and utilizes expert groups as part of its governance strategy. You can see on the slides that there are two types of expert groups, depending whether the Commission in whole or just one department set up the group. But the task is always the same. It consists in helping the Commission with the preparation of legislative drafts. That goes hand in hand with hereditary influence. Therefore, it is important to emphasize that the Commission is, of course, not bound by the proposals. You can also see there are different types of members in each group. Type A combines the individuals appointed in a personal capacity, acting independently and expressing their own personal views. For example, professors from all scientific fields. Type B, that are individuals appointed to represent a common interest shared by stakeholder organizations in particular policy area. They do not represent individual stakeholders, but a particular policy orientation, an orientation which is common to different stakeholder organizations, and that may be proposed by stakeholder organizations. Type C then, in the broad sense, are organizations in a broad sense, including companies, associations, NGOs, trade unions, even universities or research institutes, law firms, for example. I think you would call them perhaps the think tanks as well. So this is a kind of group for any organization. But it may be of interest that even member state authorities are involved in these expert groups. For of course, member states have to implement, after all, the European legislation. And also other public entities, such as authorities from non-EU countries, including candidate countries, EU bodies, offices and agencies and international organizations are involved in the expert groups. Not in every expert group, but they can join these expert groups. So you see that expert groups shall perform two tasks at least. On the one hand, they are supposed to contribute expertise to legislation, but at the same time, they are also supposed to represent specific interests, whether of the norm addressees or of the member states, which, I already said it, ultimately have to apply EU law. So, also proven successful, I think, at the European level. The inclusion of external knowledge has exhibited some fundamental problems when applied within legislation. And three of these basic problems shall be addressed right now. The first problem concerns the reception level. So far, I've only described the ways in which external knowledge can be introduced into the political decision-making process. The quintessence of the thought description is that knowledge input is characterized by plurality. But this knowledge must also be able to be received by the state organs, i.e. it must first be understood and then be evaluated. And this raises the question of whether the state decision-making organs have a sufficient and appropriate receptor system. However, the plurality of informants and information inevitably entails the danger of being overwhelmed. This is because the information provided to state institutions must be evaluated not only in their own disciplines, but also in their interactions. And this is precisely the interdisciplinary challenge. The second problem is specific and can, the way I see it, be solved by procedural or organizational law. It consists of the ambivalence between knowledge and decision-making in democracy. Assuming the necessity of expert advice on the one hand, the more independent the experts are, the higher the reliability of their expertise is rated by politics, and especially by the public. Then, however, their involvement is legitimized solely by their expertise. On the other hand, in order to strengthen their democratic legitimacy, they are required to be linked to the state's legislative bodies. In this case, however, the suspicion of manipulated knowledge will linger. Also, this tension cannot be eliminated entirely, it can certainly be reduced. From a constitutional and thus equally from a legitimatory point of view, it is essential that the democratically legitimized sovereign authority is both empowered by the expertise to make decisions and retains the right of final decision. Contrary to the often heard call to follow the science in the context of climate change, it must not be overlooked, especially in a democracy, that ultimately every decision is only a prioritization and as such falls within the realm of politics. As accurate it is that expertise is a basic condition of politics, this expertise must be limited to the slide of, once again, must be limited to the provision of provable facts. And that said, the assessment of the facts is no longer the sole responsibility of science. It shares this task with politics. And which conclusions are ultimately to be drawn from the facts and their evaluation is the task of politics alone. And as long as this policy shall be cast in legally binding instruments, this task falls, at least in Germany and the European Union, to the Parliament. Only one of the opinions that politics is in every respect and without exception determined by numbers, data, and facts, and then indeed the only question for the alignment of politics is who has got the better databases. However, even this basing assumption is false, at least for liberal democracies. Rather, with reference to Josef Alois Schumpeter, it must be repeatedly recalled that the liberal democracy does not follow any explicit normative goal, but instead provides a method for establishing social order. This method is dependent on knowledge, but must always act autonomously and in view of the final responsibility, both in the case of existing and lacking knowledge. Incidentally, and this shall only be insinuated here, this problem can be mitigated by ensuring both a consensus between experts as well as plurality in respect to the input of knowledge. That is because a consensus indicates that the knowledge imparted is not based on politically relevant assessments. If in addition the expert consensus is also ensured in respect to interdisciplinarity, there's a very high probability of its correctness. The third problem is of more abstract nature, as I promised you in my introduction. It consists of the danger of an increasing inclusion of epistemology in politics, or in other words, the fact that a primarily political debate is dealt with as a knowledge conflict. If, for instance, theoretically founded knowledge, so expertise, and empirically acquired knowledge, experience, are irreconcilably opposed to each other in a discussion, the concept of knowledge is understood both rationally and emotionally. This makes politics difficult. By way, for example, reference shall be made to the discussion on panel policy. Here, crime statistics point towards increasing security, whereas the feeling of most people suggests decreasing security. Or refugee policy and climate change are other examples of areas where different types of knowledge are at odds with each other. Such an epistemocracy would destroy democracy. For knowledge alone does not make decisions, and does not abolish the necessity for decisions. Rather, specialized knowledge of different disciplines must be transparently available to all participants in a democratic discourse. In this respect, legislation remains an interdisciplinary challenge, but this challenge can be overcome in a democracy. So I have come to the end. Thank you for your attention. I haven't gone into environmental law as much as I wanted to now, but I see perhaps we can go on in the discussion. I look forward to your impulses, observations, and experiences. And I also like to learn how you deal in your practice with knowledge that you either ask for or that is brought to you by whomever, and that certainly sometimes questions politically predetermined objectives. Thank you very much.
Thank you so much, Dr. Rossi. That was fascinating and a really interesting discussion of European legislation and related to expertise that's necessary. I think we all recognize the importance in an increasingly complex society of the need for outside expertise as well as internal expertise. And you've identified some of the problems that presents. And so we have some questions already for you, and I'm going to try to pose those to you, and I may throw in some of my own as we go along. The first question comes from Matt McGee, and he notes that in the United States, private sector experts are very much involved on a particular subject matter, and they often try to influence legislators to choose a particular policy position. How can a drafter who's tasked with writing a bill on a particular subject learn from that subject matter expertise, from that expert, without allowing that expert to influence the policy decisions in such a bill?
Oh, this is a very good question, and of course we have the same problem in Germany as well. I try to emphasize that the way I see it, not any proposal coming from civil society, coming from associations, coming from the industry, coming from NGOs is kind of lobbyism. That's to say that it's only trying to influence the bill in a certain direction. But the way I see it, it's both. It's trying to, of course, to put their own interest in front of other interests. But at the same time, I think involving these groups is important for getting to know what the needs of a certain group is. This is the first thing I wanted to say. The second thing, and now answering the question, is that I think the German system where the ministries are responsible for drafting bills is more perhaps than, I can't say it exactly in the United States, but it's really very in the hierarchy of the ministry. And that's to say that the one person in the small department which is drafting the bill in the first draft, he or she depends on what in the end the whole ministry will say to this drafting experience. And for we have the other ministries involved as well, there will be no chance for only one certain interest to come through. And at least when it comes to the public reading in Parliament, it's very obviously whether or not a certain section had too much influence on the bill or not. So I think it's the plurality that ensures a kind of neutrality in the end. Let me put it like this.
We can see that tug really between that neutrality, right, and being pulled in a certain direction. And that kind of prompts our next question that's related, and it comes from Samantha Samuel. who's an international legislative drafting consultant, and she writes that as legislative drafters working with other stakeholders, we have to connect the dots to prepare the legislation. But how do we do so without being seen as influencing the process in some way? It's such a fine line for individuals to walk. How do you suggest navigating that?
With a great self-consciousness, I think. You should keep on going. I myself have good experience with external drafters of legislation because mostly they are more independent from political parties than other. Of course, there may be the danger of being influenced by certain economic groups or by certain aspects of common goods, environment, I mentioned as an example. But in the end, I trust more in neutral drafters than in drafters who are just fulfilling what a political party is saying. Then in my whole scheme, I didn't mention the political parties very often. In reality, I should mention them much more. And for me, this is the main problem, that the ideas and even exact formulations, exact wording of bills are often not proposed by, in Germany, the ministries or perhaps external drafters, but by drafters within the political parties. And they have more influence than all other persons.
Our next question comes from Jonathan Wilson. With all of the expertise in so many interdisciplinary fields now, and the law certainly permeates all of these different fields, right? How does the parliament or the government make a decision on what law to formulate?
Once again, I have to admit that there, I think, is a big lag between theory or constitutional demands on the one hand and practice on the other hand. To be honest, I think the parliament is not able to make great changes in bills that has been presented by government. But that may be a particularity in Germany, because we have, as all of you know, probably we have the system that the majority in the parliament, yeah, you have a similar system, but in Germany it's we don't have these the president. In Germany we have the majority of the parliament, which of course signs everything that the government proposes. But if again we have self-consciousness of the deputies, I think they have much power to give build a direction that has perhaps not been wanted by the government or by a certain group of interest. And of course, I should mention that the parliament itself has the right to initiate bills as well. They can, if they stick together, they can give opposition, can act like an opposition to the government as well if they want to. But as I got it right between the lines, you are right in your presumption that the parliament has not so many possibilities.
Mm-hmm. Thank you. You know,
yeah.
Go ahead.
I'm sorry, but just one more note. I mentioned both the national level as well as the European level, because the problem is that in the European level, and this is what I wanted to show you, is that the Parliament has less rights than the European Commission. It has no such right to initiative, and this is why it is incredible that the national parliament has to adopt legislative acts from the European Parliament, from the European level, where the European Parliament is not invoked in such a deep way like we used to have it in our member states.
Thank you for that. One of the great things about our conference is bringing theory and practice together. And this, I think, are good discussions about where they need to come together and where we can each contribute to that course of knowledge. We have another question from Claudia Ribeira. And she asks you, she notes that you said that the RIA and LIA belong to the internal governmental drafting phase, but she wants to know, do these reports go together with the draft law? Are they sent, for instance, to the Parliament?
Which reports? I didn't get it.
The RIA and the LIA, she identifies, belonging to the internal governmental drafting phase. She wants to know if those reports go together with the draft law when submitted to Parliament.
They go together, that's it. But it's not more than just a recommendation. And to be honest, I can't see a very high importance of those reports. Whatever it's written in these reports, it doesn't influence the content of the bill in the end to a very high level. It's just a recommendation.
Thank you. Antonio Delicado sends a question to us. How do you see the use of the legislative footprint instruments, and is there a specific instrument that you would recommend to all of us?
In Germany, we had the discussion about a kind of legislative footprint 3 or 4 months ago, I think. And in the end, the Parliament decided a bill where the legislative footprint is just necessary for the parliamentary phase. If you remember, of course you know it, the legislative procedure, only concerning this last parliamentary phase, there must be a legislative footprint now. But the essential and the crucial phase, of course, is the governmental phase, the initiative phase, as well as on a national level within the federal government, as well as on the European level within the Commission. And there's no such a legislative footprint. So you can't see exactly which text was invoked by whom. You can't see it. The way I see it, I was asked, I'm quite unsure. On the one hand, it's perhaps good to know from whom a certain wording comes in a bill, and you can perhaps make sure that I can see perhaps that there might be an influence from a lobbyist or from an other interest group. But the only fact that a certain wording has been formulated by such a private draft or a private interesting group does not mean that the bill in the end, that the law in the end is not a good one. So this is what I'm always thinking about, and I have no solution, to be honest. But the way I see it, there might be a difference between who was influencing a certain bill, and in the end, is it a good law? Is it not? Is this a bad law? I don't know. Could have been better? So the way I see it, a legislative footprint, I think it could diminuate the acceptance of a law, and this is a certain point. You know, a law, an act being adopted by a parliament always comes with a certain formal acceptance. Because the parliament has adopted the law, it is accepted. Because the government was invoked and several public authorities have been invoked, it is accepted. And when you now see that certain aspects are proposed by private interest groups, then the exception of the whole law, not only of the act that we are talking about, but perhaps all acts, are diminuted. And this is where I'm still thinking about what could be a good idea. Transparency, to make a last point, transparency is for sure a good thing in general. As I already mentioned, that plurality of interest groups and plurality of the possibility to give information, to give knowledge to the legislator must be, it could be a good idea.
You know, yesterday we had a very good discussion around ethics in legislative drafting, and you know, this really raises many of the same questions. And colleague Mohammed Hassan Hizmir has raised the question of ethics involved here, and is interested in your thoughts. You've mentioned transparency, which is such an important part of this. Might add to that questions of, is there any attempts at screening for conflicts of interest, and how do you think, how well are drafters in this process dealing with the ethics involved in these kinds of issues?
Yes, thank you so much for that question, which of course goes deep into the topic. Once again, two answers. Once again, plurality, I think, is a good instrument to ensure moral standards. Because if, and I try to show you, if there are several authorities involved in such a legislative procedure, it can't be only one person, or it can't be only a special group that is able to give a certain direction to the legislation. So if there are many, they control each other, not only controlling in a judicial way, but also in an ethical way, in a social way at least. And there you have the consciousness of everybody, of every person who is involved. So plurality would be the first answer. And the second answer is that, of course, each group itself should be thinking about what he or she is proposing. So when the economy, to use this ambivalence between economy and ecology once again, when economy knows that there are other interests as well, climate change, social welfare, ethical standards all over the world, then I think the proposal could be a good one. So I think it's better to tie the private persons and the private players, all players, to their own standards, than to have a formal control over the end, that's to say, over the parliament. But last sentence, perhaps, in Germany, we just got a new kind of lobby register act, where at least I think in the European Union, we already have it since 10 years, for 10 years or so. But in Germany, we just have it now for a couple of months, so that every person who is involved in legislation must be registered. And this is value for me as well. For example, when I join a committee on federal level or on the level of the Länder for giving an advice to a bill, I have to register, which I don't like really very much, because I feel myself very independent. I would belong to the group A, if you remember, the expert groups, people that are independent, that are not giving any advice, we're not following a particular interest. But even I have to be registered now, so it can be seen what have I said and who was asking for me, which, by the way, is always the committee itself. then inside the committee, there may be political parties which propose their special experts, but in the end, the way I see it, it's formal, the committee, so there is no independence. This is the last thing that, the last act that Germany adopted a few months ago, but it refuses to introduce entirely legislative footprint. So I'm interested in which countries do have such a system and which experience do you have, and if it's successful above all, if it has changed the legislative culture.
Well, thank you so much, Dr. Rossi. There are so many more wonderful questions, I have to tell you, that our audience has posed, but we are now, I'm looking at the time, and I think we are just about out of time. And hopefully the kinds of questions that we're seeing in the Q&A, we can continue that discussion in our breakout rooms. On behalf of all of us, and I can see from the many questions in the audience, we've thoroughly benefited from your wonderful presentation today, and we thank you so much.
Thank you, Lou, and thank all of you. I will join the one or other breakout room as well, so we can continue our discussion then. Thank you.
We look forward to it.